This is Paul Turner, the Immigration Barrister at Imperium Chambers. If you've got an immigration problem, please contact me and I'll do my best to help you. Please subscribe to my channel and hit the notification button for any and all, hopefully all, immigration news. Today I'm going to be talking about some recent case law which affects or deals with family life applications and or appeals, and whether there is anything left of the Chikwamba argument or principle. I suppose everyone will be asking themselves, or anyone that's not familiar with immigration law or the detail of immigration law, what is the Chikwamba argument or principle? It is an area of law that has led to a significant amount of litigation, most recently in the case of Alam Anor versus the Secretary of State for the Home Department, 2023 UWCA Civ 30. So again, turning back to the Chikwamba principle, it relates to a case dating back to 2008, which I'll come to. It applies to in-country spouse or partner appeals where all of the requirements of Appendix FM are met, apart from the immigration requirement, i.e. the person who makes the application while they're here illegally. The appellant will generally have proved that they meet the suitability, eligibility, English language and financial requirements, but at the time of the application they held no valid leave to remain, hence illegal. The case of Chikwamba discussed what weight should be attributed to this fact in an Article 8 balancing exercise, and in particular whether it would be disproportionate to expect someone to have to return to their home country simply to make an application for entry clearance that would be bound to succeed. The House of Lords in the case of Chikwamba stated that it would only be in rare cases that the tribunal should dismiss an appeal under Article 8 solely on the grounds that the appellant could apply for re-entry or entry clearance from their country of origin. However, the case is often incorrectly relied on to state that there is little to no public interest in removing appellants who fall into this category. This was one of three cases decided as way back as 2008 by the House of Lords, and they were broadly pro-migrant. Since then we have new legislation in cases which row back on what might have been seen to have been a liberal high point in this area. As more recent cases have made it clear, this is not the view adopted by the Home Office or the Court today. This principle, the Chikwamba principle, was revisited in a case called EUSS, open brackets, section 117B6B, Chikwamba 2020 UK UT 129, and most recently in the case of Alam, which I've quoted above. In the case of Alam, the Court of Appeal made it clear that all the Chikwamba principle does is confirm that it might be disproportionate to remove a person whose entry clearance application would be certain to proceed. It's clarified that Chikwamba is not authority for the assertion that there is no public interest in removing a person. Alam, like the case of EUSS a couple of years ago, clarifies and further narrows the principles set out in Chikwamba. They confirm that there may be circumstances in which removal would be disproportionate, but the fact that the appellant would succeed in an application from their home country for entry clearance is only one relevant factor which should go into the pot during the Article 8 balancing exercise. So this is a significant retrenchment since 2008 and has been going on fairly consistently. So when the question, I suppose, arises, will removal be disproportionate? As always, this is a question of fact for the decision maker, usually a first-tier judge. Again, as I try to advise clients, if you are making such an application or facing an appeal, the more work that is done earlier, the better the chance of success. It is quite frankly not good enough to expect the Home Office or the Tribunal to accept your or your partner's word that you cannot live in another country, or that it would be unreasonable to go back to make an application from abroad. Evidence is required. Relevant factors will include, but certainly are not limited to, the appellant's immigration history, attempts to regularise their status prior to the application under consideration, and any other family or friends that they have in the UK, including children, and of course any previous allegations of deception or overstaying. One potentially relevant factor in the last year or so has been the temporary suspension of priority applications for entry clearance applications in family cases. The reason for this suspension was due to the war in Ukraine and the scheme set up by the Home Office and a reprioritisation of services. Appellants could legitimately argue, I suppose, in that time that separation would take a minimum of 6 months or so before they returned. Now, however, and appellants need to be aware of this, the Home Office is reintroducing priority service for entry clearance applications. I covered this in a previous video. So, whilst it will cost upwards of about £500, the argument that removal is for an indeterminate period of time is not as strong as it used to be. And to be fair, it might be worth, if you had proper advice on returning home and making an application, to actually do so rather than spend the time, trouble, expense and stress of an appeal, especially if your application is bound to succeed. The case of EUSS and Alam do unfortunately narrow the principle set down to Chikwamba. Put shortly, the view adopted by the courts has hardened against migrants' appeals in recent years. It is also the case that Chikwamba was decided prior to the introduction of Section 117B of the Nationality and Immigration Act 2002, as amended by the 2014 Immigration Act. This requires the Tribunal to consider in all cases various factors including the importance of maintenance of an effective immigration control and the limited weight to be attached to private or family life established while a person was here unlawfully. The term they use is precariously. To recap, it is essential when preparing these cases that there is more than just the appellant and sponsor's assertion that they could not live in another country or be temporarily separated. Detailed statements, bundles and high quality evidence and advocacy will be essential. Although the Chikwamba principle does in theory still exist, just simply by citing the case and saying I can't live in another country or I don't want to be separated from my partner is simply not going to be good enough. More work will need to be done, and even that will not guarantee the success of a case. As I mentioned, with the reintroduction of the priority service, it may well be worth going back and applying for priority service, maybe a quicker way to regularise one's status. There is a side point here which I think is worth mentioning. If one does make an application in country and the individual is an overstayer or doesn't have leave, and they succeed in an appeal, they'll be put onto the 10-year family life or private life route. If they make the application from abroad, they'll immediately be put onto the 5-year route. Now, if one succeeds in an appeal and is put on the 10-year route, as soon as one is issued with leave, one could switch into the 5-year route because obviously they wouldn't be an overstayer. But of course that would necessitate a new application and a new Home Office fee. So it is worth consulting with your immigration lawyer, and I'm happy to help if you don't have one, as to whether it is actually worth pursuing an appeal, or whether it's worth considering returning. Now, I know return is not something that is attractive to many people. Indeed, very few people actually go back and make an application for entry clearance. However, in my experience, it can often be far quicker for that to happen, as long as your lawyer prepares everything before you leave the United Kingdom. My experience has been that where people have decided to go home, we've prepared all the paperwork, obtained all the documentation, so that when the person goes back they can quite simply make the application. And this was obviously prior to the war in Ukraine, and they would often find themselves back in the United Kingdom within a matter of months. And with the priority service, apparently they'll make a decision within 15 days, so it could be even quicker. So, in short, the Chikwamba principle and the principle that it would be unfair to remove somebody who's bound to succeed is an argument that's going to be increasingly difficult to make out before a judge. Not impossible, but increasingly difficult, and it will also be it will be fact specific, i.e. it will turn on the circumstances of your case and its preparation before any court or appeal. I hope this video has been helpful. Please contact me if you want any further advice on this matter or any other immigration matter. I hope you're well, do stay safe, thank you very much for watching. Please again subscribe to my channel and hit the notification button. This is Paul Turner, the Immigration Barrister at Imperium Chambers.